I have good excuses. They're not graded yet, and I'll make sure that I get the numbers posted before the end of spring break and give you back your tests that Tuesday. We haven't finished with the great case of Florida Star versus BJF, and this is the case where the little newspaper published the name of the victim of a rape, and she sued the newspaper for violating the Florida law that made it a crime to publish the name of a rape victim. And the court rejected the newspaper's argument that the publication of truthful information can never be published, and decided that it would proceed incrementally, little baby steps, with a much narrower test or standard for whether the newspaper's speech was protected. That is, if what the newspaper published was truthful, if it was information that was lawfully obtained, and if it was about a matter of public concern, then it would be protected by the First Amendment unless there was a need for liability in order to serve an interest of the highest order. And the court quickly found that, yes, this was truthful, yes, it was lawfully obtained, yes, it was about a matter of public concern, a serious crime in the community, and now we reach the point, the interest analysis, the narrow tailoring part of First Amendment analysis. Though Justice Marshall in the BJF case only once mentions narrow tailoring, that's what he's doing. So the first question is, what are the interests that Florida is protecting by this law? And Florida argued three closely related interests: protecting the privacy of victims of sexual offenses, the physical safety of victims of offenses, and that would be an especially strong interest in this case because the perpetrator of the crime was still at large. And knowing who she was and so on might put her in increased danger. And finally, the goal of encouraging victims of sex offenses to come forward, complain, be willing to follow through with the prosecution and testify and so on. And there was some thought in Florida, as elsewhere, that if there was publicity given to the name of a rape victim, that would be a deterrence to coming forward and being willing to prosecute the rapist. So how does the court treat those three interests? They sound plausible, at least. The court doesn't poo-poo them and say, oh, well, those are insignificant interests. Those wouldn't justify penalizing publication of truthful information about a matter of public concern. Rather, the court accepts that those are highly significant interests. Then the question is narrow tailoring. Is there a good fit between what Florida is doing here with this law and serving those three closely related privacy interests? And the court concludes that for three independent reasons, there's not a good fit. The liability is not narrowly tailored to serve those interests. Why not? Well, first, look at how the newspaper came by this information. They sent their intern down to the police station and copied off the police report right out of the press room, open to the public. If the state was really concerned about protecting the identity of rape victims, it wouldn't put that information out there in a highly public place. The government has failed to police itself by doing that, and that can hardly be said, Justice Marshall concludes, to be a narrowly tailored means of safeguarding anonymity. And then the second reason why the court finds a bad fit between interest and means is one of exquisite subtlety, and if you get this, you're really getting it in this course. The court points out that this law, under this law that BJF has invoked, liability follows automatically from publication. That is, it's unlawful to publish the name of a rape victim in an instrument of mass communication, period. And she brought a civil suit based on a common law theory of what's called negligence per se. And I promise that you'll never have to know anything about this on any test in this course, but just for your general interest, negligence per se is a theory for, in civil cases, where somebody has violated a law intended for the protection of a class of persons and inflicted injury by violating that law. And it may be a criminal law, as in the case of the Florida statute in BJF. Violate the law, cause damages, you're liable. That's negligence per se. For example, if you're doing 50 miles an hour going down Hearst and you run into a kid on a bike, your violation of the gross violation of the speed limit would make you liable for the injury caused to the kid on the bike. That's negligence per se. The state doesn't have to prove that you were in fact negligent, acted in some way unreasonable in the circumstances. Rather, just the violation of the law is treated as negligence per se. And that was BJF's theory in the Florida case. They violated the law, I was hurt, they're liable. That's a correct reading of the law. Justice Marshall points out that that's quite different from the common law tort that we looked at Tuesday, the publication of private facts, which requires private facts, and that the disclosure is highly offensive to a reasonable person, no such requirement in this Florida law, and that they be not newsworthy, no such requirement in this Florida law. Liability follows automatically from publication, regardless of whether the identity of the victim is already known in the community, regardless of whether the victim has voluntarily called public attention to the offense, or whether the victim has otherwise become a reasonable subject of public concern, maybe a celebrity, something like that. So that's troubling. And then Justice Marshall points out that there's no scienter requirement, which is a Latin term that means blameworthy state of mind. It means fault, the way we talked about it in libel. It means a blameworthy state of mind. A scienter requirement is that you were either negligent, at the very least, or more likely you acted intentionally and hurt somebody willfully, evilly, blameworthy. But there's no scienter requirement here. No requirement that BJF prove anything about what the newspaper's intent was, or even that they were negligent. And here's the subtle point. That means the perverse result of not having any scienter requirement is that truthful publications challenged under this law are less protected by the First Amendment than even the least protected defamatory falsehoods, those involving private figures. Get it? The perverse result, if BJF were to win, if liability automatically follows from publication, is that truthful information about her, disclosure of her name, would be less protected by the First Amendment than the least protected defamatory falsehoods. What are the least protected defamatory falsehoods? Think about it. What are you whispering to me? Libel, yeah, what sort or about whom? On private figures, right. Remember, in the aftermath of Sullivan, the Gertz case, every libel plaintiff has to show some kind of fault, some kind of scienter. That is, the private figure must show at least negligence. And under this law, you don't have to show any scienter requirement at all. The Florida law, you don't have to show any scienter at all. So disclosure of her name is less protected than libel of a private figure, and that's a bizarre result. Right? Yeah, the difference between scienter and actual malice. Well, actual malice is a form of scienter. Scienter is the generic category of blameworthy state of mind, and actual malice is one example of a blameworthy state of mind. But it's not. It's really not intent to defame anybody. It's your state of mind vis-a-vis the truth, not the person, not the target of your libel. It's your state of mind about the truth. Did you know it was false, or did you act recklessly with regard to truth or falsity? That's actual malice. That's a form of scienter. So there's two independent reasons why there's not a good fit between the statute making the newspaper liable and the state's interest. And then there's a third reason why the court finds Florida's showing of interest inadequate, and that's the facial under-inclusiveness of the statute. It only forbids disclosure of the name of a rape victim by a, quote, instrument of mass communication. In other words, a newspaper, a television station, radio station, some entity that's in the business of mass communications. And the law does not, as Justice Marshall points out, prohibit the spread by other means of the identities of victims of sexual offenses. For example, the neighborhood gossip, who spreads the word, hey, did you hear that BJF, and so on, which may be just as injurious to the victim, maybe more injurious to the victim, than having her name tucked in the back of some newspaper police blotter column read by people, or skipped over by people who've never heard of her and didn't know her name. It might be, the closer to home it is, her coworkers, her neighbors, and so on. If this was disclosed, that may hurt her more than having her name disclosed in an instrument of mass communication. And Justice Marshall points out that what the state has done is to single out this kind of disclosure and leave unprotected the disclosure in every other form of communication. And if it really wanted to protect the privacy of rape victims, it would do so. The state would do so even-handedly across the board. That disclosure by anyone of the identity of a rape victim would create liability. So the court concludes under the Smith versus Daily Mail test, that's this test, truthful, lawful acquisition, and so on, concludes that the statute is not narrowly tailored to a state interest of the highest order, and therefore what the newspaper did was protected by the First Amendment. Even Justice Scalia concurs in this opinion, because the law, as he puts it, leaves appreciable damage to this supposedly vital interest unprohibited. And so it's not a good fit. Justice White, remember, not a big friend of the First Amendment, dissents here. He had written the opinion in Cox Broadcasting versus Cohn, which involved the disclosure of the name of a rape victim, where the name had been obtained from court records. He had written that opinion. He dissents in this one, saying that what the court has done is to obliterate one of the most noteworthy legal inventions of the 20th century, the tort of publication of private facts. That is over-the-top exaggeration. The court did no such thing. It certainly did impose on the state tort law, take the tort of publication of private facts, First Amendment rules over and above the common law rules, just the way the court did the same thing in Sullivan with libel. So that somebody who now sues for publication of private facts has to prove not only the elements of that tort, publication of private facts, highly offensive and not newsworthy, but also has to meet the BJF First Amendment requirements that are superimposed on the state law. If it's truthful information, and it always is, if it's lawfully obtained, if it's about a matter of public concern, then you do this interest analysis and decide whether liability is a narrowly tailored means of serving whatever interest the state comes up with. Questions about that? Tina?
In order to survive the tort, it needs to be newsworthy of a public concern. So isn't the only real substantial requirement to get with the BJF is narrowly tailored to a statement of interest? If it wasn't truthful and of a public concern, it wouldn't have passed the state.
I think you're right. I think that's right, that there's a pretty nearly complete overlap. I mean, assume truthful information. Otherwise, we're talking libel if it's false. Assume truthful information, lawfully obtained. The court leaves open, in the BJF case, what happens if the information is unlawfully obtained by burglary or bribery or wrongdoing of some sort? Does that oust the publication of First Amendment protection? That's still an open question. I mean, we know from and we'll get to that in a minute in another case, we know from Pentagon Papers that somebody's wrongful acquisition of the information, disclosure of the information, did not deprive the Times of First Amendment protection. We know here that it was lawfully acquired. What happens when it's unlawfully acquired? We'll reach that in a minute. But if it's a matter of public concern, that's basically synonymous with newsworthiness. If it's a matter of legitimate public concern, that's basically the same as newsworthy, which would defeat liability under the common law. But some state might get it wrong. And here's where I think the California Supreme Court was inaccurate in Schulman when it said that newsworthiness is synonymous with First Amendment protection. Because you can imagine a state court deciding that the information was newsworthy. That doesn't end it for First Amendment purposes. Because if it was true information, lawfully obtained, and it was newsworthy, still you have to satisfy the interest analysis of whether there's a good fit between the alleged interest supporting liability and it's narrowly tailored to serve those interests. That liability is what you have to serve those interests. Then there's the case of Bartnicki versus Vapor, which involves the unlawful acquisition of information. It's a cell phone conversation that was illegally intercepted. It's illegal to intercept cell phone conversation. It's a federal crime. In Pennsylvania, it was also a state crime. And there was both civil and criminal liability built into the laws about intercepting cell phone conversations. Somebody, person unknown, intercepted and recorded a cell phone conversation between Bartnicki and somebody named Kane, who were teachers union officials involved in a strike situation against the school board in some town in Pennsylvania. And they talked tough. One of them saying, we got to blow off their front porches, talking about the school board members if they don't do the right thing. Somebody, whoever intercepted the cell phone conversation and recorded it, delivered it to somebody who gave it to a radio talk show host, who also gave it to the local newspaper. The tape was played on the radio. The transcript was published in the newspaper. And Bartnicki sued, claiming that his right of privacy had been invaded by this publication in violation of the cell phone laws. And the case went to the Supreme Court, where Justice Stevens wrote the opinion. And he recognized that what you have in this case is a collision of extremely important values, a conflict between interests of the highest order. The interest in free dissemination of information concerning public issues, so let's hear what these teachers union officials are up to, and the interest in individual privacy, specifically the interest in fostering private speech, because the really speech interest on both sides of this case. The teachers union officials were arguing that if somebody can intercept our phone calls and publish the contents of them, not only does that invade our privacy, we certainly have a reasonable expectation that our cell phone conversations will be private, but it dampens, it chills our speech. If we know or assume that we're speaking in complete confidentiality and privacy, we're free to say what's on our mind. But if we fear that we're being recorded and this may be broadcast to the world, we're going to be extremely guarded in what we say. So the speech interest on both sides of this case. And this does involve, Stevens acknowledged, an intentional disclosure of an illegally intercepted phone conversation. And the publishers, the radio station and the newspaper, had reason to know that the interception was illegal. No secret. Everybody ought to know that intercepting phone conversations and the disclosure of the contents is illegal. But the court said the subject matter of the conversation was of public concern or newsworthy. And the wiretapping laws that prohibit the disclosure of what was said on the phone prohibit pure speech. This is not conduct. It's not the interception that is being complained about here. It's the publication. It's the pure speech, what was said during the conversation. And Justice Stevens referred back to the Pentagon Papers case, where somebody clearly had acted illegally in getting the classified materials to the New York Times, just as in the Bartnicki situation, where somebody had acted illegally in intercepting the conversation and delivering it over the transom to the radio station and newspaper. We don't know who did that. Somebody acted wrongfully. Does that deprive the publisher of First Amendment rights? And the court says no. In this case, privacy concerns give way when balanced against the interest in publishing matters of public importance. A stranger's illegal conduct does not suffice to remove the First Amendment shield from speech about a matter of public concern. A tough case. Stevens attracted votes for his majority from Justice Breyer and Justice Sandra Day O'Connor, who wrote a separate concurring opinion saying, well, this decision is extremely narrow, we're going to go along with it, on the understanding that it's premised on two factors, that the media, the radio station and the newspaper, had acted entirely lawfully. They were blameless up until the moment of publication. They hadn't stolen the recorded the